Hello to everyone. I hope that you made a profit of this short break. Express my gratitude to be a chairman of the next two panels, and as well permit me to express my gratitude to all key speakers, to Professor Watson, who really had a very interesting lecture today, to all other key speakers, of course, to the organizers, especially to Nina. If I can say, her impact was decisional to the success of this conference, but as well to all other speakers, to all other participants who used to present us the results of their research, and of course to the all others were we waiting to present us what they were researching about. In order to save some time for our discussion, which is forthcoming at the end of this and all of others, permit me please to invite our first speaker in the session. That is our colleague, Lekić, who is coming from the University of Belgrade. She's a student of Faculty of Law and Faculty of Political, and she has prepared a very topic about British history, but a very interesting part of British history concerning dissecting human corpses and the evolution of dissecting of human corpse, starting as a crime and being at the end of this evolution a matter of medical science. So, Sofija, please take the word.
Thank you, Professor. I will try to share my screen now. So, hello everyone. My topic for today is the legal perception of dissecting corpses in early modern Britain. That is the evolution from the Murder Act of 1751 to the Anatomy Act of 1832. Now, when we speak about dissection today, it seems like quite a commonplace practice. After all, it would be almost impossible to imagine medical studies without the students encountering dissection as a part of their training course. However, the situation in early modern Britain in the 18th and the first half of the 19th century was much more complicated. First of all, the only bodies which could be even considered for dissection were those of executed felons. This stemmed from the religious belief of the people back then that dissecting the body or refusing the proper burial to it could lead to the eternal damnation of the soul, which made the public pretty apprehensive when it came to the matter of dissecting bodies. However, not even all the corpses of the executed felons were dissected. In 1540, King Henry VIII, decided that 4 corpses per year would be allotted to the medical practitioners for dissection. Over a century later, in 1663, King Charles increased this number to 6. However, as we can all see, that was still a very small number compared to the needs of the medical practitioners. Certain changes happened in 1751 with the creation of the Murder Act. The full title, or the long title as it is sometimes called, of this act was an act for better preventing the horrid crime of murder. As we can see from the title itself, the prime focus of this act was not anatomy as a public interest. Rather, it was still considered to be a form of post-mortem punishment. The prime motivation behind the creation of this act was preventing the crime of murder, and to that end, post-mortem punishment was issued for all felons who committed murder after their execution. They would be either anatomized and dissected or gibbeted, that is, left to hang in chains after the execution. Now, technically, all the bodies could be dissected. There was no more restriction of the number of bodies per year which could suffer this fate. However, obviously, this did not happen. In certain regions of England, dissection was the more popular method in the decisions of the judges. In other regions, gibbeting was preferred. However, a question arose, and it was a question I first posed when starting to research this topic. What is the difference between anatomization and dissection? The Act itself does not define either of these processes, and the medical practitioners of the time did not do so either. Rather, they used both terms interchangeably as best sufficed their needs. However, it could be said that anatomization is a process of cutting the body to check on the lungs and heart, and afterwards the brain, in order to confirm that the felon has truly been executed and not survived the sentence. This was a true spectacle for the crowd who witnessed the execution itself. The whole audience would gather around the dissecting table and watch as the anatomists cut the corpse and show to the public that the criminal has truly been punished to the worst extent. On the other hand, dissection was an educational process witnessed only by the medical society, in which the anatomists cut the body in order to truly understand the mysteries of its structure and functions. It was done privately, only with the presence of those who studied medicine, and was much more thorough than anatomization. Now, as we look at the provisions of this act, it may seem that the situation for the anatomist was much better than it was before. However, statistics suggest that only an average of 14 corpses per year was dissected on account of this act, which was still quite a small number. At the same time, the number of medical practitioners and students raised, as well as the level of their knowledge, which further deepened the gap between the demand for the bodies and supply of them. Naturally, a black market started to appear. The first stage in the development of the black market of cadavers was the appearance of the body snatchers, or the so-called resurrectionists. First off, those were the anatomists themselves who dug up the bodies from the graves and dissected them. However, it didn't take long for other people to start digging up the bodies and selling them to the anatomists in order to gain profit. Now, there was an interesting loophole in the English law of that time, that the body was not considered to be property of a person. Therefore, after the person died, it did not become property of those who inherited the other things. This reflected in the fact that the theft of a body from a grave was not considered a theft, that is, a felony, punishable by execution, but rather a misdemeanor of public indecency, which was only punished by a fine. This was ruled in the court ruling of 1788, Rex versus Lynn, and as we all know, since the English law recognizes the power of precedent in court rulings, this became the law. The irony was that the true grave robbers who sought to take objects from the grave could get into the situation of being caught while robbing the grave and say, no, I'm not a grave robber, I'm just a body snatcher, and be let off with a much less strict punishment on account of that. This led to the further enlargement of the practice, and more people became body snatchers and thus provided the anatomists with the needed cadavers. However, the situation changed once again in 1828 with another court ruling where 2 doctors were convicted because of obtaining bodies from the body snatchers. The judge ruled that the only legal way of getting bodies for dissection was that provided by the Murder Act, and thus it became possible to criminally prosecute all the anatomists who got their cadavers through other means. This proved to be the first incentive for a change in the legal regulation of anatomy and dissection, but I will get back to it later. Now, I began with a talk about the black market of cadavers, and for a time, it was only the theft of the bodies from the graves. However, the family and friends of the deceased obviously did not want the souls of their loved ones to be condemned to eternal damnation, so they set traps over the graves or even stood guard over the grave for a few weeks at times to prevent the body snatchers from taking the body. This led to the practice of the resurrectionists being much more difficult, and sometimes too much time had passed before the body snatchers could take the body, which made them less valuable for the anatomists. It didn't take long for the body snatchers to recognize another opportunity for easier income. The first string of murders for anatomy that we know of happened in Edinburgh in 1828 by the notorious crime pair of Burke and Hare. They started out as body snatchers, taking the bodies from the graves, but soon crossed the line and started killing people and selling the fresh bodies to an anatomist called Robert Knox. At the trial, Hare confessed to the crimes and thus escaped the sentence, while Burke was hanged and dissected afterwards. They confessed to a total number of 16 murders, although there are certain sources that say that the number could have been as large as 30. This proved to be a large impact on the English society, reflected, among other things, in the coinage of the term Burking, which signified a murder in the name of anatomy. This term exists even today, but in a slightly different meaning, that is the murder by strangulation, since that was the preferred method of Burke and Hare. Burke and Hare is a story which was further adapted in many movies, plays, books, and etc., and it is well remembered even today. But contrary to popular belief, it was not the final straw which made the English law change. Rather, a few years later in London, an even more sinister string of murders happened by Bishop, Williams, and May, popularly called the London Burkers. They also killed people and sold them to anatomists, but the numbers through which they did it reached as many as 60. This caused an understandable panic in the public of the Great Britain and caused the public and the parliament to react and change the laws pertaining to the dissection of bodies. Now, as I already mentioned earlier, the first initiative for changing the law came in 1828, when the obtaining of bodies for dissection became illegal through any other means than the Murder Act. The first person to begin this process was Jeremy Bentham, a very well-known legal scholar, and a few weeks later he was followed by Henry Warburton, who actually made the Act become reality. The Act was created in 1832, and its full name was the Act for Regulating Schools of Anatomy. As we can see from the title alone, anatomy is now recognized as a thing of public interest, and it is the main focus of the Act, at least officially. The dissection of executed felons is no longer permitted, which is an attempt at dissuading the public of considering dissection to be an awful punishment reserved only for the worst people. At the same time, dissecting of bodies became legal for all bodies except for those where the deceased or his next of kin expressly wished for the body not to be dissected. However, this was all official talk and what was written in the Act, but the reality was much more complicated. The higher classmen usually refused the dissection, and they were better protected from involuntary dissection since the amount of corpses was larger. At the same time, the poor often accepted the dissection in order to avoid the high expenses of burial, or in some cases they expressed the wish not to be dissected, but their wishes were disregarded. This led to the public to believe that dissection ceased to be a punishment for the crime of murder and became a punishment for being poor. Obviously, this did not go well with the public, but that is another question which I will not go into detail today, since I covered only the period to the creation of the Anatomy Act. Now, to conclude, I would like to draw some parallels between the two acts which I researched. They seem a bit different when we look at them at the first glance. The one was created to prevent the crime of murder, the other to organize the schools of anatomy. However, when we take a closer look, we see that both of them held a certain intention to prevent murders. One as a deterrent in the form of post-mortem punishment, and the other through providing enough bodies so anatomy murders would not be anymore needed. At the same time, the Anatomy Act put the end to the resurrectionist era, since it wasn't needed anymore for people to dig up the bodies from the graves. What happened usually is that the former body snatchers took the bodies of the poor, presenting themselves as the next of kin, and then sold them to the anatomist. But there was no more need for people to guard the graves, put traps, etc. So we can conclude that the change from the Murder Act to the Anatomy Act was progress in some form, but not much. It was rather a foundation for further reforms, which caused the English legal system in this area to become what it is today. So with that, I would conclude my presentation. I would be happy to hear any comments, suggestions, or questions in the discussion, and thank you for your attention.
Thank you very much, Sofia, for this wonderful lecture. And now, let me call our colleague, Jakub Babushka, who is coming from University of Warwick School of Law, and who has a similar and also very interesting topic about possibilities human body being a part of legal traffic. Jakub, please, this virtual floor is yours.
So, good morning, everyone, ladies and gentlemen. Today I will like to discuss how law has treated the body across the ages. It might seem quite general, but I will restrict myself to an analysis from as early as 17th century and try to emphasize the pivots in understanding of human carnality by linking them with relevant judicature, case law, and codes. I'll try to show how the discussed subject always seems to be ahead or beyond law, that is, drives legal change without ever being clearly defined. One may even summarize that the legal treatment of human body is a constant succession of errors, inadequacies, and vague statements. Hence, my argument is that even though the legal concept of body constantly evolves, the resistance of regulated matter hints at an existence of what's famous psychoanalyst Jacques Lacan called sedimentary concept, a core of matter which remains unchanged despite all of the revolutions. My presentation will start by discussing the treatment of body remnants in Anglo-Saxon courts. Then I will try to evaluate the relation of body to the concept of property, specifically quasi-property. Also, the historical causes of changes in law will be assessed. And finally, I will summarize historical background to extract synthetical conclusion regarding the general trends in treatment of human body and its parts. So, I will begin by illustrating the silent part, which I believe is the materiality of body. I will evoke here an anecdotal case from Florida. It is a case of John Timiriasev, who sued hospital after his leg was discovered in the garbage. Doctor threw amputated limb into the garbage, complete with text indicating it belonged to the former patient. Timiriasev based his claims on the grounds of two arguments. First, emotional distress due to the intensity of mental anguish resulting from the discovery. Secondly, for releasing his private medical information. His amputation was made public by the description of the leg, and at least it was disclosed to waste management and law enforcement personnel. So it can be clearly seen that once the limb is subtracted from the body, it ceases to have any dignity. Timiriasev claims almost entirely avoid any specific mention of specificity of body. It rather reduces it to either information or a disturbing imagery. This is where we are, and I will try to search for the grounds of such current state in law. So let us clarify at the beginning that property means two things. First, that is the right to a thing, and Secondly, that is the thing itself, the subject of property, that is from Latin res. So it is certain that under modern conception of law, both understandings of property were somehow merged. And the only discussion is whether this understanding is absolute one or qualified as qualified interest. So it might seem to be narrow, but I will argue that the whole richness of subject can easily flourish in both narrow framework. So the beginning of legal history starts in England since Norman conquest, where the church claimed exclusive authority over the dead. The purpose was threefold. First, preventing sacrilege, then burial grounds simply belonged to the churches, and finally, property jurisdiction. So basically, apart from that, on the side of an individual, there was no property, but only the duty, which lied on the narrowest relative to bury his the dead relative. So basically, the earliest American case which tackled this subject was one of widening of Beacon Street, where court adjudicated that the right to the king has rights to bury and try to protect the remains of the dead person, and adequately it's related to the right to choose a burial ground and sepulture according to one aesthetical taste. And it seems that, for example, text of commentary reduces the right to protect body by kin solely to the property of monument. However, even though the no property rule was always accepted by the courts in America, we can see some peculiar phenomena. Prior to 1804, there existed an precedence of arrest of a body for debt. For example, in 18th century, poet Dryden was arrested. His body was arrested, and then St. Bernard's Taylor body was arrested due to his death before the funeral. So we have here some paradox that on the one hand, every court declines any legal standing to property on the dead body and declines any value to it, and at the same time it considers that arrest of a dead body has some financial sense. So I would argue that here we witness some transition. Beforehand, American law commentaries there was consensus regarding the recognition of no property in dead body, but on the factual level, the decision of courts were ruling otherwise. So, for example, from the revolution started in 1904 with a case from Pennsylvania, which ruled that actually there is a property in corpse, and starting from that event, every court adjudicated in America that there are either a partial property law in a corpse or absolute one. So what made it possible to go from that place, from the non-property to some partial property? It seems that it is a uniquely American legal status, which can be called quasi-property. It recognizes limited rights to kin to protect and control human remains, but relies upon the features which are free of the social cultural association or stigma of property status. So basically, it tries to argue that it's possible to treat something like property without calling it property. And what drove American system to that conclusion? I would argue that the grounds are in historical facts. I would single out the Civil War here, because during Civil War there were 4 characteristics which were emphasized in the nature of body. First, the medical dissection became acceptable, and also the practice of embalming. Secondly, the human remains and services associated with it began to be commercialized. And thirdly, the methods of identification were developed. So finally, the movement of human remains from religious sphere, from the ownership of churches, came to the public sphere, but still the private parties were totally omitted. Always the intervention of third party was necessary. So what do we understand now as a body? I think that quite instructive may be the case of 9/11, where the families of victims of the terrorist attack argued for separate burial. Nonetheless, over 1,000 of victims were never remainings of 100 victims were never identified in the after the tragedy. So basically, the American court said that an undifferentiated mass of dirt without something tangible or identifiable, there cannot be, if we have only undifferentiated mass of dirt, there can no be quasi-property right. However, today we have to do with bodily transplants, bodily materials, which, for example, bone grafts, after being manufactured, are harvested from cadaver, then cleaned and processed, and then can be clearly recognized as property. Meanwhile, in cases like Vrije case, depicts that some simple parts of body like blood, urine, or hair cannot be recognized as property of no one. For example, if a suspect throws away his urine at the police precinct to the sink, the urine cannot be considered as the destruction of urine cannot be considered as destruction of property. So even his own. So another thing is what makes generally possible to differentiate part of body as a property is work skill processing. Work skill processing is an exception derived from Australian case Woodward versus Spence from 1908, which argued that if a person has, by the lawful exercise of work or skill, dealt with a human body or a part of a human body in his lawful possession, but it acquires some attributes differentiated from a mere corpse awaiting burial, then it becomes a property. And we can see that it applies also to living beings. Because, for example, in the case of Moore versus Regents of the University of California, leukemia patient had his cells taken by a university professor and on their basis, highly lucrative commercial products were developed, and the court came to the conclusion that any ownership should be denied to the patient. So basically, the ownership of our own cells is denied to us. And finally, we can see another extreme when it comes to the famous Bodyworld exhibition, where cadavers were exhibited in prepared form. And there, it is considered that it's legal because of the plastination process. So finally, I will try to summarize it in 2 points. The status of living body is legally void until immortalized through processing. By tracing the jurisprudence from the early origins of the no property rule, qua church property, to the contemporary use of the work skill exception, recasting of biomaterials from res nullis to res is only possible in the case of death or and is necessary to even create the concept of rights in that field. Nonetheless, in no case an individual has right to one's own body. The body can become res only for third parties. Therefore, we will arrive at a dubious situation where only third parties are recognized as having property rights in biomaterials and protected by the law in the exercise of those rights. They thus gain a degree of control over the fate of our biomaterials, individuals' biomaterials, which is totally denied to us or human souls. So thank you. And I invite you to ask any questions.
Thank you very much. Thank you very much. Now, we have another very interesting topic. Well, we have finished with we have finished with the dilemmas of the dead, and now we progress with some other topics concerning those who are living persons. And first of such two topics is one where our colleague from Faculty of Law and Criminology, Vrije University, Brussels, Karianne will speak about. It is a dilemma about compulsory polio vaccination. I suppose that is a topic primarily focused on some historical dilemmas in Belgium, but I suppose that some parallels will be drawn with the mandatory vaccination about coronavirus. So Karianne, please, you can address to us.
Okay, thank you very much. Can everyone hear me? You can? The sound is clear? Good.
Yes, it is.
Okay, please. So thank you very much for the invitation to speak. And I'm very happy to meet you online, although I would have preferred to meet you live, of course. But indeed, the circumstances of the current global pandemic force us to do this online, apparently. So as you pointed out rightly, my topic has parallels with the current debates. For today, I will stick mostly to talking about the polio vaccine, which is mandated, which is compulsory in Belgium. At the end of my talk, I will draw some parallels to the current debates in Belgium about the COVID-19, by some called a vaccine, by others perhaps gene therapy, depending on your perspective. But my main focus will be on trying to understand how polio vaccination came to be compulsory in Belgium, and what we might learn from that with respect to current debates. I have first a question. I know this is unusual because it's usually the speaker who receives questions, but I have a question. Is there any, is there such a thing like polio vaccination mandated in Serbia? Nina?
Sorry, my microphone was off. As far as I know, yes, we have a lot of mandatory vaccination for little children,
Including for polio. Or perhaps you don't.
I'm not 100% sure, but I think yes. Milos, can you?
Well, perhaps the other.
Do you know maybe?
To be honest, I'm not completely sure.
Yes.
I share your opinion. I share Nina's opinion. So I suppose it is.
It
but
might be, yeah.
When I was a kid, and now the time when our son is obliged to take another kind of vaccinations, it is different, because right now we have some kind of 5th-valent, 6th-valent vaccines. So I'm not sure what those vaccines are consisting of. So I'm not completely sure tell about different types of vaccines.
Yeah, there are multiple vaccines for children available, and just to give an overview, I saw somebody mentioned in the chat that there is a compulsory polio or some type of childhood vaccination in Poland. In total, I calculated, but this is just for I had access to data just for the European Union. No, actually it was Europe. Out of 32 countries, I believe only 10 mandate vaccination. So that's a third. So just as the global context or the European context there. So let's get started with my presentation about compulsory polio vaccination in Belgium. A short overview. First, I'm going to share a short intro with some statistics. Then I will talk about the mandate situated in the Belgian legal system. Then I am going to approach my historical legal study of polio vaccination and how it was mandated. I have decided to divide it into three phases, three historical phases. That is just a first and a preliminary attempt to tackle understanding the topic, because as far as I have been able to investigate, there hasn't been much research about this topic, at least not from a historical legal viewpoint. So three phases I will discuss one by one, and then finally I will talk a little bit about compulsory polio vaccination and human rights, and there I will draw some parallels to current topics. So let's first get started with a short map. For those of you who don't know what polio can lead to, it is most feared because it can paralyze mostly children. And here is a map that shows where polio is still being detected today. And I want to point out, I'm not sure if do you see my browser? You do. So I want to point out these two countries, Nigeria and Pakistan. Here are wild polio viruses still circulating. Wild polio virus, that just means a virus that naturally occurs in nature, so to speak. And the other countries which are marked yellow, those are regions, countries where the polio virus is circulating because of vaccines. You heard that right. That is not a mistake. I said that is vaccine-induced polio. Now, I will not venture into a medical debate about this, but I just want to point out that this is the current situation for today. And then some statistics. So of every 200 children who get infected by polio, according to statistics from the World Health Organization, 0.5%, as indicated here, become irreversibly paralyzed. And of those 0.5%, 1 in 200 again of those who are paralyzed, so that's a total of 0.05%, may die without assisted breathing. So they become, their breathing muscles become paralyzed, and that causes death. So that is what we are talking about. That is the law that we are talking about in concrete terms. The last case was detected in Belgium in 1979. The last case in the Netherlands was detected in 1993. Well, why am I referring to the Netherlands? Because interestingly, in the Netherlands, there is no compulsory polio vaccination. Now, this study, I chose not to do comparative research between Belgium and Netherlands, because that would be too complicated within the scope of just a talk of 20 minutes. But it's interesting to note that there is a distinction in how polio vaccination is being approached in both countries, and that would certainly be worthy for further exploration. And then in Europe, that would be 1998. So Europe, as you could see in the map, is free of polio, and yet we continue these campaigns. And so how did this come about? And now I will situate the mandate in the Belgian legal system. I will talk about the royal decree. I will explain what that is, the Health Act, and the separation of powers. So here you can see a copy of the archives of what is called in Belgium Le Moniteur Belge, the publication magazine, official publication magazine of laws. So the polio vaccination was mandated through a royal decree issued on October 26th. And it came into effect starting at the beginning of the next year in 1976 or 67, rather. In Dutch, we speak the other way around. I always mix those two up. And so what is important in this law is Article 1, that polio vaccination should be administered between 3 and 18 months of age. And that in case of non-compliance, there will be penalties. I will talk more about these penalties in a little bit now. What is important, I think, for everyone to understand is that in Belgium, every royal decree must be based upon an act of law. And the difference between those has to do with the separation of legal branches. I will talk about that next. But first, for the polio mandate, what is crucial, I have found, is that the Health Act of September 1st in 1945, and that Health Act says that, according to Article 1, all possible measures against an epidemic can be taken by royal decree. And the only condition which is mentioned within the law is that the so-called Superior Health Council should be asked for advice. So they have, this council has a very crucial legal, thank you, Nina, for checking that. So the Superior Health Council has a crucial role to play. And it's also important to mark that this Health Act was made in 1945. So that's right after the end of the Second World War. So it's a specific historical context which may help to understand why, in my view at least, I would argue that there is very little checks and balances included in the Health Act. And certainly if there is, of course, the advice of the Superior Health Council, but that is a sort of a medical checks and balances, and legal checks and balances, there is virtually none. And yet this Health Act still is used today, which I will explain later in my presentation. So that's Article 1, and Article 5 states that there are fines. It's possible to get fines and imprisonment when you refuse to do so. I have investigated to what extent this was actually being applied, because sometimes laws are made and they are not really applied. And my research has shown that there are not frequently, but at least on a couple of times a year, my impression is there are judgments in which the judge sends people, usually they give people fines, but sometimes they also send people to prison, which is remarkable. And let me remind you that we are talking about a disease which has been eradicated for 40 years, in which, at least in the Netherlands and in the majority of European countries, there exists no mandate. And within that context, people are given jail times. They're not literally sent to prison, because in Belgium, if I am correct, when you receive a prison sentence below 6 months, it is not executed. And the reason is because there are too many people already in Belgian jails, so there is no space, basically. And then I come to the last part of the Belgian legal system with respect to the polio vaccination mandate. And this is a really important part, I think, because it talks about separation of powers. So as you all know, the doctrine of separation of powers states that there is at least some degree of separation between the legislative, executive, and judicial powers in order to make the government work in a fair way and to have a state that's organized according to the rule of law. Now, royal decrees are issued by the executive branch. So that is important to remember. A royal decree is a law. It has the value of a law, but it is issued by the executive branch. Whereas acts of law are enacted by the legislative branch. So that means by the parliament. And this is really important because it means that the polio vaccination mandate, and in fact, in theory, all measures that are based on the Health Act of 1945 can, in principle, escape scrutiny by the parliament. So they can escape the parliamentary debate. And that is quite remarkable if you think about how far-reaching these measures can be, as we've all been able to observe in the past 2 years in terms of infringements upon human rights, and I will talk more about that at the end. But it's also remarkable for other reasons in terms of side effects of vaccination, and the question as to what degree there is a right to violate people's physical integrity, in this case, baby's physical integrity, and that, of course, should be balanced with the right to protect the public from certain diseases, contaminant diseases. But in any case, my research has shown that this mandate exists, and there has been no parliamentary debate about this, and this can happen again. And then I want to dive into a little bit of history around how this mandate came into existence. So I will start with the first historical phase, which I have, and this I have given some dates to it, and this is really a little bit arbitrary to some extent. It's just helped me to be able to better structure a certain number of historical events and to kind of group that together into which I believe could be historical phases that help to shape the transformation from voluntary vaccination to compulsory vaccination. So I will talk about the first vaccination campaign in Belgium, then about which were the two key debates in that with regard to that campaign, and then a little bit about the international context. So first, Belgium in 1958 started with the first mass vaccination campaign. This comes after, if I'm correct, the vaccines in America. There was a vaccine in Russia as well, which was developed, a polio vaccine, which were developed around 1954, 1955, and then it was first tested in America. I don't know if, well, the students are too young to remember this, but maybe the other ones may remember, the professors may be aware of the so-called Cutter incident in 1955 in America, whereby 100,000 children were injected with a vaccine or they believed to be a polio vaccine, but it was actually, it contained the live virus, and several children died and became paralyzed because of that, well, product error, so if you could call it that way. And so this this caused perhaps some hesitation and a willingness to wait for the first results. That is a hypothesis. I'm not stating that as a fact, but it may explain why it took a while before American vaccines came across Europe and started being administered here. And so the first campaign in Belgium was voluntary. And this was, as you can see on the right, the number of people who allowed themselves to be vaccinated was about 6 in 10 people. So I should say that back in those days, sometimes adults would also get infected by polio and become sick. So everyone can get infected by polio, but mostly children may get ill. However, also it happens that adults do get ill. So in that respect, this graphic also represents both children and adults. And one, just as a little anecdote, one of the most famous people to become infected and get paralyzed by polio is President Franklin Roosevelt. And then there were 2 key debates that accompanied the first. Do the numbers add up to 90%?
I think so.
Yeah, it's possible that
It might be just a typo, just so you know, to double check. No problem.
It might be. I have 3 very young children running around always, so sometimes I might make a little mistake there. So yeah.
Perfectly understandable. I have one, and I respect everyone who has more.
Yeah. So this is the warning for all the students who have no children yet. Think carefully before you start having 3 in too little time. So there were 2 debates, and I have tried to represent these 2 debates in a graphic overview. So one debate was about the age, and that was about whom should we target? Should we target the entire population, or just the children and perhaps the young adults? And this was, of course, also a debate about the cost, because these vaccines did cost a lot of money at the time. I don't have the exact numbers, but I can imagine that the question of cost certainly played a role into this debate. And ultimately, it was chosen to first vaccinate children between the age of 0 up until 15 years of age, and then in a second round of mass vaccination, people between the age of 15 and 40 years of age were offered the vaccine. Why not after 40? Because it was estimated that there was virtually no chance of falling ill and developing serious symptoms. Of course, there are always exceptions, but in general, not. So that was the first debate. And the second debate, as you can see here, the second debate was about the vaccine itself. So there are roughly 2 types of vaccines. The first vaccine is the so-called Salk vaccine. Salk comes from Dr. Salk, who invented one type of vaccine, and this is injected, and it contains inactivated polio virus. The other vaccine is an oral, it's called the Sabin vaccine, and that is an oral polio vaccine, and it contains live virus, but the virus is attenuated, so it's made weaker. And so this, you remember in the beginning I showed the map with yellow, a lot of yellow countries, well, in these countries, the oral vaccine is, or in most of them, the oral vaccine is administered. And this is a very, very cheap vaccine because you don't need needles to inject. You just put it in the baby's mouth. So it's very cheap. It's very easy to administer. The only problem is that sometimes these viruses, although they are attenuated, they are weaker, they have been shown to develop into normal polio viruses, so to speak, and they can actually cause new infections in children who are not vaccinated. So by vaccinating a part of the population with this type of virus, other children are endangered. So that's an interesting feature. I thought that's an interesting thing to remark. And then in Belgium, I want to add, in Belgium, for the voluntary campaign, so in this historical period, the choice was made to administer the more expensive Salk vaccine. I have not been able to find out yet why, because I'm trying to get access to the archives of the Superior Health Council. But this is it turns out to be quite a Sisyphus task to get access to these old archives. So this is, for me, this is continuing research. And then what is also important, I think, to understand the mandate is that there was a strong international context, and Belgium played a strong role in the international fight against polio. And the international context also had an impact on Belgium. For example, Belgium had a national association against poliomyelitis, and there was a European one which had its headquarter in Brussels. I think almost all of you, but I'm just gonna add it for the students who've never had the opportunity yet to visit Brussels. This is the famous atomium. That is certainly, it's still there, of course, and it's certainly worth a visit. And this picture dates from 1958, when there was the very famous World Fair located there. And so there are the International Poliomyelitis Assembly. So my point is, as I've already explained, the Superior Health Council played a major role in mandating the polio vaccine, and the Health Council, of course, was well embedded in an international context of the fight against polio. So I think that is an important aspect to understand why, for example, it was mandated in Belgium and not in other countries. If you're constantly at the forefront of the battle as a doctor, and then at the same time have to advise the government on how to battle polio, that may certainly play a role. And then we come to the second historical phase. Okay, so how many more minutes do I still have? Perhaps I get a message here that
Yes, we have to pay attention on proposed time for presentation. I'm sorry, it's very interesting, but I don't know, maybe 5 minutes, is it enough for you?
5 minutes is a little bit short. 10 minutes would be able, that would be feasible.
Okay, be short as much as you can, please, because we have another presentation after you, and then time for discussion and
Yes.
breaks proposed for lunch, etc. I'm sorry, really.
No, it's okay.
In this manner.
Okay, I will stick to 10 minutes to finish the presentation.
Okay.
Thank you. So the second historical phase consists of another vaccination campaign and also international influence again and internal debates in Belgium. So I can be relatively short about that. The second mass campaign was also voluntarily, and it was the Salk vaccine that was being used. And then regarding the external influence, it's important to understand that there are two countries which have an influence on Belgium. It's the Netherlands and France. And in the Netherlands, there was a voluntary vaccination model that may have played a role into understanding why it took quite a while for Belgium to adopt a mandate. But in France, what is crucial is that France started to mandate polio vaccination from 1963 onwards. And in 1965, 2 years later, this doctor called Dr. Lekić organized a French conference, and that was, to the best of my knowledge, the first conference organized in Belgium on that topic, on law and polio vaccination, and notably how to, with regard to mandating it. And I think that 1965 is really a landmark year, because that was really the year in which the idea came into existence to mandate vaccines. It was already being done in France, and then it was a small step to do it also in Brussels, in Belgium. So which were the internal debates conducted at that time in Belgium? You could say there was an initial hesitancy to mandate vaccines, but after a while there was more and more, under the influence of France and the developments there. There was more interest to mandate the vaccine as well in Belgium, and I have been able to find two doctors who played a role there. One called Dubois promoted the 7 vaccine, and another one, a Flemish-speaking doctor from the north of the country, promoted the Salk vaccine, or he was in any case against promoting the 7 vaccine for the reasons which we've already discussed, notably the danger of developing serious side effects as well as secondary vaccine-induced infections. And then the third historical phase, that was 1966, the year in which vaccination was made compulsory. I will briefly touch on important historical events in that time and the so-called the era, the zeitgeist in which era, which was the grand narrative which was important at that time. So, as I've already said, polio vaccination was made mandatory on October 26th. There was also a ministerial decree, a so-called report to the king, which is published right before the mandate of polio, and it contains a reference to the advice of the Superior Health Council from 10 March 1965. So that proves the idea that 1965 was a crucial year to explain the mandate. And that was this is the Minister of Public Health, Rafael Hulpio, who mandated it. And so then the historical events, there were some political unrest. There was the government fell, so there was also a political crisis. So the question is, was the polio vaccine mandate enacted hastily by the new government? That is still an open question for me to investigate further, based on the arc of being able to get access to the archives of the Public Health Ministry at that time. And then the zeitgeist, so there was the 60s were known for their civil rights movements and counterculture, but also I would add scientific prudence. So on the one hand, there was a desire to control polio. On the other hand, there have appeared to be a desire to thoroughly study the side effects. That is a hypothesis that still needs further research. And then finally, a couple of things that seem to be important in terms of when you force vaccination is to talk about human rights, I will briefly discuss the Universal Declaration of Human Rights, and then the right to compensation and exemption and a proportionality test. And then I am finished after that. So interestingly, in the Belgian Health Act, there is no reference to the Universal Declaration of Human Rights. Of course, this is very logical because the Universal Declaration dates from 1948 and the Health Act from 1945. So that seems very logical, of course. But there was never, to the best of my knowledge, an update of the Health Act either, based on the Universal Declaration of Human Rights, and it's still being invoked to justify royal decrees. And that was the case for the polio vaccine mandate, and also for the current attempt to mandate COVID-19 gene therapy. So it is still very relevant. However, at this moment, as I've already said, there is a parliamentary debate about whether or not the COVID-19 mandate should be made or not. And then finally, I've been able to find one historical attempt to compensate vaccine injury victims, and that was from 1975, but the law was never adopted. And to the day of this day, there are no compensation foreseen. And what is crucial here is a landmark case that was decided only last year, so a very, very recent case by the European Court of Human Rights, again, the case of the Czech Republic against Vrije. And this is a very important case law because it refers to the idea that there should be a proportionality test and that there should be compensation foreseen, or that's how I have read it. Perhaps other people will read it differently. But the European Court decided that it was justified to mandate certain vaccines for certain diseases based on a series of criteria that such mandates should respect. And so I suggest more research for the idea of adding a compensation and exemption clause to the polio vaccination law. And finally, I just want to mention that the Health Act offers no clues whatsoever for a so-called proportionality test. A proportionality test is a standard from a human rights perspective. And Professor De Hert is someone who proposes proportionality criteria in order to decide whether a vaccine mandate should or should not be enacted and become a law. And the three criteria he proposes are that a measure is appropriate, that there is absolutely no alternative measure that can be taken, and that there should be a strict balance between restriction of individual rights and public interest. And so the question is, and that is a question for more further research, whether this polio vaccination mandate passes the proportionality test. And that's it. So thank you very much for listening, and I will be glad to answer any possible questions now or afterwards in the discussion.
Thank you, Karianne, very much. And let me notice that the results which are coming from Karianne's presentation are that the strict boundaries between personal legal area and public interest are not clear yet. For example, the Convention on the Rights of the Child entitles the parents to upbring their children in accordance with the ethical, emotional, and national values of their own family and society. And the same solution is transplanted into Serbian Family Act. But you can see it is not always easy to resolve such dilemmas, which are such and similar dilemmas, which are coming from legal norms, because it is obvious that the society and the state authorities are always observing the families and the parents, but of course it is very needed to find such a very thin boundary separating personal legal decisions and, of course, what is proclaimed as some kind of public interest. I think that similar, let me say, eternal dilemma is one which is the subject of our next topic, because it deals with euthanasia. Does euthanasia support culture of death, or it is a kind of releasing a sick suffering from unfortunately expected, but unneeded pains and suffering? And right now, let me call our colleagues who are coming from School of Law, University of Warwick, Natalia, Deptała, and Justyna, Michalak, to tell us something more about that.
Yes, hello. Can you hear us? Can you hear me well, and can you see me?
Yes, we can see you.
Yes, oh, perfect. So as we are introduced, my name is Natalia Deptała, and I'm representing School of Law from University of Warwick. And with me here today is my colleague Justyna. And we should highlight here that apart from strictly legal interests, our academic focus oscillates between a variety of humanistic and social sciences. We try to focus from from subjects like history, from philosophy to archaeology, what creates a rather holistic perspective for different normative questions. And today, our aim is to present you the results of our investigation of the problem of euthanasia. However, here we would like to take up a little bit different perspective on this issue, and we try to analyze it as an example of a developed tool against the medical futility, and to focus on this understanding rather than analyze its theoretical associations. But nevertheless, we should highlight here that making an end-of-life decision constitutes a major challenge for bioethical deliberation and political governments all around the world in modern democracies. On the one hand, it touches upon fundamental convictions about life, death, and the human condition. But on the other hand, it's deeply rooted in the religious traditions and historical examples. And this shows us a great social-cultural diversity. And the bioethical discussion of such cultural issues oscillates between liberal individualism and a lot of examples of cultural stereotyping. Although there is local consensus, what goes beyond radical individualism, those positions are not neatly matched with national cultures or religious denominations. Instead, we see here that there is a relevance of specific situateness of religious beliefs and cultural communities, and they become visible. The status, the role in individual situations, for example, which may be consensual or conflicting on the level of personal perspective or family relationships or broader social context. For example, as a majority or a minority culture within, and here it comes with a political system. And it is still very common to identify culture with national characteristics or a religious domination, or just to equate religion with an official theological doctrine. And for example, the representatives of the civil liberties movement, they underline the right to an autonomous decision and a dignified death. On the other hand, Christian advocacy groups, they stress the sanctity of the human life and the absolute prohibition of killing. And finally, we can give an example of Jewish commentators, for example, who refer to halakha, and they emphasize the moral difference between withholding and withdrawing treatment. Speaking about culture of death, as is in our topic of our today's speech, we should move back to 1995 when the first bishop of Rome, who is Pope John Paul II, in his encyclical letter, The Gospel of Life, he sounded an alarm. In the midst of a culture that congratulates itself on being enlightened and progressive on matters of human civilization, is very in danger of giving into a culture of death. And referring to the Code of Canon Law, it's unquestionably repudiated by the Catholic moral tradition, and it is regarded by the canonical scholarly tradition as a type of homicide. Moreover, the supporters of this perspective argue that the practice of euthanasia bears a resemblance to the action of human sacrifice, which has been practiced, for example, by some indigenous nations, but it was also very different among various religious practices through the ages. There are even some supporters of canon law perspective who dare to compare euthanasia to the sacrifice performed in pre-Columbian societies. Personally, I must admit here that I'm quite skeptical about this thesis. The reason for that is that among Aztec societies, the human sacrifice was an example of a death ritual, which was accepted by the traditional custom law or divine law, which had a significant position among the legal system of pre-Columbian societies. And there, for example, for Aztecs, it was such a human sacrifice. So it was a means of extending life by balancing and feeding the universe. So we should here ask a question. We should call it then a culture of death, or maybe a culture of life. But moving back to this whole concept of euthanasia, it has been already familiar to us from ancient Greece. But at first, it didn't have such a negative, controversial overtone as it does today. At the beginning, it referred to a peaceful way of dying, which was free for torment and fear. And the oldest written testimony on this matter is believed to be a passage from the Comedy of Pertinos from the 5th century before Christ. In which the euthanasia was portrayed as an example of a good death, one that is very gentle and one which was proceeded without suffering of a person, an individual. And in a very similar sense, this understanding was used by Suetonius, who described the death of Caesar Augustus, which was very painless, and he even used an expression exitus facilis, so a very simple death. So we can see here in the ancient understanding of euthanasia, we can see here that it's a practice which was oriented towards individual freedom, and we can even see here some resemblance to Stoic thought. When we move to the later times, the taming of the element of death, the objectification of it, had to change its discourse, because at the time when European societies were ravaged by wars, pandemics, etc., new forms of spirituality emerged. And this represented mostly a Christian adaptation of the ancient ideal of a, let me say, happy death, of a peaceful death. And therefore, in the Middle Ages, we can see a lot of works of the Ars Moriendi, who contained advice on which contained advice on how to behave in the face of imminent death. But over the time, it became a rather collection of advice on the art of living. So it moved to this ars vivendi problem. When we move a little bit further, modern times, we can see that they brought a specific change in perspective of euthanasia, and the subject of reflection became the person, became the individual, the man, and his and also his earthly life. It was no longer about God or eternal life. And in this context, it's worth referring to the concept of Morris's utopia, where we have in utopia we have this example of ideal state, which assumes general welfare and good health of its citizens. And in the event of its deterioration, all the members of community should take care of the sick. And for example, when the problem of incurability arises, the sick person was supposed to was not supposed to resist death, but only accept it. We can move here to another thinker who was Francois Bacon, who drew a distinction between external euthanasia, which involved the relief of suffering without killing, and also the second approach, which was internal euthanasia, and it involved some kind of a personal preparation for death. And in contrast, in 19th and 20th century, we can notice has brought a pro-euthanasia discourse. And we can start with Friedrich Nietzsche, who used the mouth of Zarathustra, and he formulated the postulate of ending one's life. Together with other representatives of pro-euthanasia thought, they didn't show a desire for death, but neither did they focus on this will to live. And here I will let my colleague speak.
Thank you very much, Natalia. My name is Justyna. I also study at the University of Warwick. And now I will present a bit more about the modern legal perspective. I will focus on common law, that's the most familiar to us since we study English and Welsh law, but also on the continental law. So first of all, looking at the question of euthanasia through this lens of common continental law systems is a fascinating example how different legal systems, which are from the same region, which operate and share many cultural similarities, many cultural norms, etc., may differ fundamentally on such a controversial topic. In the United Kingdom, active euthanasia, or an active killing, as well as assisted suicide or someone helping another person to end their life, are illegal according to Section 2 of the Suicide Act of 1961. And despite those clear statutory provisions, the question of euthanasia is nonetheless a complicated one in English and Welsh law. A particular issue arises in cases regarding relieving someone's long-term suffering. So a separate approach can be observed in case law regarding medics. So according, for instance, to the case of Dr. Adams from 1957, which is a very important case, if a doctor's action aims to relieve pain, even if these measures accidentally shorten a patient's life as a kind of side effect, it is still acceptable by law. And the intention of wanting to help a patient out so that they do not experience pain seems to be an acceptable action under law. Nonetheless, some confusion arises with regards to what is the primary purpose of a doctor's action. If the primary purpose is hastening the moment of patient's death, then according to the R versus Cox case from 1992, such an action is unlawful. So this leads us to very interesting debate. Shouldn't a good doctor know that giving a patient a particular medicine can lead to shortening life? Moreover, how to prove what constituted the primary intention of the doctor? And regardless of these questions, the law seems to be emphasizing the approach that, and here I quote, the aim of a medical treatment is not simply to prolong life at all costs, end of quote, which was shared in the guidance published in 2018 by the British Medical Association and the Royal College of Physicians on when doctors are permitted to allow patients to die. Furthermore, looking at the case law in the area of parents wanting to end their children's suffering leads to showing us that there is even less clarity in the area of euthanasia in English law. And particularly two cases in this area seem to be very important because they show how difficult to comprehend it is, the court's approach here in this area. So the first case we will look at is the Francis Inglis case from 2010, where a mother killed her son with brain damage, but she suffered from depression, from PTSD. But because, according to the definition under the English law, she did not lose control in the moment of killing, it was rather cold-blooded and pre-planned, she was charged with murder and sentenced to 9 years, later reduced to 5 years of prison. But on the other hand, we have a very similar case when in 2010, Kay Gilderdale case, mother killed her daughter suffering from a chronic fatigue system. She pleaded guilty to aiding and abetting suicide, but nonetheless, the jury refused to prosecute her because they said it's immoral. And even there was some sort of public, the jury was very angry at the prosecution services for even taking the mother to court. Thus, these two cases highlight how deeply difficult it is, even for courts, to maintain an anonymous approach towards euthanasia, which does not convict one mother of murder and lets another mother go free. This also highlights the human element in criminal law. Different juries may decide similar cases very differently, and their views on the matter may differ, leading to polar opposite results. A different approach can be observed in Switzerland, which, alike England and Wales, bans active euthanasia and mercy killings. In cases regarding ending prolonged medical conditions, administering a lethal injection is illegal. Nonetheless, Swiss law allows for supplying the means for committing suicide or acting by omission if an intention is not acting in selfish motive, for instance, monetary gain. So this leads us to a so-called suicide tourism in Switzerland, where people from other countries, particularly from Germany, and who want to undergo euthanasia, travel to Switzerland for the procedure. And similarly to Switzerland, Australia allows assisted suicide from the 1st of January of this year. In the majority of the European Union member states, euthanasia is illegal, reflecting an approach similar to the English one. Nonetheless, in Luxembourg, anyone who suffers an incurable medical condition arising as a result of an accident or illness, or wishes to make an end-of-life arrangement to avoid unbearable and physical or mental suffering, may request euthanasia. And there are no residency or nationality restrictions. And similarly, in the Netherlands, a child from 12 years old can undergo euthanasia, though from the age of 12 to 15, they need parental consent. In Belgium, there is no minimal age requirement. In Spain, both active euthanasia and assisted suicide are legal. Thus, although the large majority of the EU states, meaning 23, ban euthanasia, it is interesting to observe how 4 different countries from the same region decided to approach the issue differently. It also reflects that even neighboring countries may fail to undertake a similar approach to the issue since it is of a very controversial nature. And to summarize our presentation, the area of active euthanasia as well as assisted suicide is a very nuanced one in common and continental law systems as reflected by the cases from English and Welsh law. Furthermore, a liberal tendency to permit more euthanasia can be observed in Europe, with Spain legalizing euthanasia in 2021 and Austria legalizing assisted suicide in this year. This presentation aimed to highlight the nuanced nature of euthanasia by elaborating on the historical, religious, and ethical implications of the problem, as well as emphasizing the real law approaches towards the issue and portraying the legal problems within the area. Thank you for your attention.
Thank you very much for your presentation. And let me now to open the discussion about all these presentations, all these topics you and me were able to hear. So anyone who is interested can just raise a hand or just turn on its speakerphone, however you want. Well, if there's no anyone who would like to ask a question to our participants. Oh, there is Professor Casey Watson. She has raised the hand. Please, Professor Watson.
Right. I don't know how to get the hand down again. Oh, there I did. Okay, I had a question for Jakub, partly because I had a hard time hearing all of his talk. But were you saying, I understood all the material about the Civil War, which was absolutely fascinating. But is part of your conclusion that the trends that you have noted is purely American, or I wasn't sure where the European medieval stuff came into this and how far your argument extends outside the US?
I think that my argument clearly applies to Anglo-Saxon courts. Regarding European legislation, I would say that they follow in some way by similar paths. For example, I would say here that the argument about transplantology is relevant here, because when we consider, I think that's some sort of consensus in the scale of international community that in Europe brought there is a wide understanding that organs cannot be sold. There cannot be, for example, market value assigned to the parts of body of a living being. And for me, it's quite provocative because on the one hand, the argument is an ethical one. It means that if we marketize, commercialize organs, it would exert an uneven pressure on impoverished part of population. But the result is the same one which was clearly present in the tackling on the human bodies in the American cases. That is, as far as we live, as the subject source of body material lives, he cannot in any way own treat his own body as property, and only after some processing it could be considered as property as such. So I think that's a more general trend. And I wanted to point out that despite many revolutions and even the radical shifts in understanding of body from some theological entity to clearly some boundary in order liberal economy, it still stays the same, that somehow not even one individualistic order considers that the body may be I think, for me ethically that's quite problematic, because clearly if you refer your body into some higher instance, for example some scientific authority or some abstract knowledge, then through the mediation of that knowledge it can become property, even if you are alive. But you by yourself, you are not able to do that. And I think that's the crux of the matter. So that's my answer.
Thank you.
And I think it's even represented in the Act from 2004, I think, in the UK legislation, when it's clearly stated like that. So I think that's the core. It fits the standards of European Union in that sense.
Thank you.
Thank you. Anybody else? Nina?
Thank you. I have a combined question maybe for Jakub and for Sofija, since they have written on similar subjects. To which extent have, in the periods that you have analyzed, to which extent were the arguments like the ones that Jakub just mentioned, so the risk that would be involved in the commercialization of the human body, present, and to which extent were there more the ethical, the religious arguments, it being generally inappropriate to do various things to a human body, be it medical research or something else, and how did those two combine in practice?
Thank you for your question. Well, in the period which I researched, I encountered more of the so-called moral arguments. That is, the public did not consider dissection to be proper practice for the good people, so to speak. That was reserved for those who committed the most horrid crimes and was perceived as a type of a punishment. I already said that the Anatomy Act tried to correct that situation a bit, but the road was quite long even after 1832. It took quite some time for people to understand that dissection is not something which should be regarded as the devil's practice, but rather a procedure which could help them live longer, healthier, and etc. So that would be my perspective. I don't know what Jakub has to say, but
Yeah, I would say that my focus wasn't particularly on the medieval ages, for example. I intentionally omitted that subject. But when we speak about it, I will say that for me it's quite surprising to find that, for example, I think the main reason why in English law for a long time the body was considered only as property, as being as able to being property in the cases of ecclesiastical churches, courts, was the fact that they were considered, and I think that's a quite fascinating argument. It was an argument based in scholastic thought that the cadaver is derived from the Latin word, if I may, 1 second. Yeah, so the reason was that cadaver, the etymological sense of cadaver is caro data vermibus, that is flesh given to worms. So in that sense, the body was never intended of that person. That remains of that person wasn't intended to be something which belonged to the order of living. So that's what drove ecclesiastical courts to recognize the only competence of church. And then about commodifying the body. I think there is a brilliant book by Mr. Gold, and it's called Body Parts, Property Rights and Ownership of Human Biological Materials. And he argues that in our times, the main consideration is commercialized, the economical, we consider bodies in terms of economy. We consider them only calculate them financially. If we restrict access to human body property, it's only because it would be detrimental to economy. For example, the court decided not to give rights to biological cells to the source subject because it would hinder the current research. So we see here always this consideration, what would be beneficial for the market. And Mr. Gold says that, and I here totally agree with Mr. Gold when he says that even though when you read the reasoning behind specific court decisions, we always see that sort of financial calculus. But on the other hand, we can identify some barriers which protect courts from adjudicating beyond some moral bare minimum of morality when it comes to the body. And I think that it proves that body is somehow, even if it's not stated straightforwardly, there's always some assumption regarded from being treated totally instrumentally or materialistically. And here, Mr. Gold suggests that we should, in our academic analysis of dead bodies, we should come back to the values which were represented by this duty to bury our relatives, and this duty is basically based on some respect and some unmeasurable in financial calculus, values which are unmeasurable in financial calculus. And he says that academic environment should try to identify what stands behind those motivations to oblige everyone to bury the relatives.
Thank you.
I hope it's addressed.
Yeah. Sofia raised her hand.
Yes, well, I have a question for Karianne. Well, it might be slightly off topic, but the talk about human rights in the context of vaccination is an interesting one for me, because I'm interested in human rights in general and the division of them into the 3 generations. And the rights to healthcare are usually considered individual rights, that is, social rights of the 2nd generation. However, with the obligatory vaccinations, or nowadays wearing the mask because of COVID, we see that healthcare is no more an individual right, but rather a collective one. So I'm wondering, do you have any thoughts about that? Can we consider healthcare something between the 2nd and 3rd generations, and what is next?
Thank you.
Thank you for your question, Sofia. Can you? Apparently, I'm not visible. Am I visible myself?
No, just your virtual background.
Just my ghost.
Here you are.
Okay, Sofia, can you clarify your question for me? What do you mean exactly by 2nd and 3rd generation?
Well, the division of human rights into 3rd generation is connected to the French phrase liberté, égalité, fraternité. So the 2nd generation is the equality rights. Those are usually the economic, social, and cultural ones, while the 3rd are the collective rights, the rights of solidarity. So my point is that while we consider healthcare something of the social sphere, it is turning into a collective thing pretty fast. So what are your thoughts on that?
Mm-hmm. Well, thank you for clarifying. Maybe I should clarify myself also that I get the impression that most of you students have been studying or reading law for a number of years, whereas myself, I've only been reading law for about a little bit over 5 months. So that explains why this is quite a challenge and an adventure for me to participate in this debate. Regarding so you're talking about certain phases of human rights, historical phases in which human rights develop. Do I understand that correctly? Okay. So I think when you talk about the transition from individual rights towards collective rights, from that specific human rights perspective, I'm not sure whether I would agree on the hypothesis that there is a transition to collective emphasis on healthcare as something collective. It is true, of course, that the idea that that we should think about the public interest, the common good, that has certainly outweighed individual autonomy in on a global and I believe unprecedented scale in the past 2 years, especially we have seen the lockdowns, we have seen the mask mandates, even for very young children, and that includes Belgium, by the way. And now there are a couple of countries in the world who go as far as to mandate vaccination. And that all of that is done in the name of public interest, of the common good. But based on just that specific observation and that specific global context that we're currently in, I'm not sure if I would conclude from that there is a transition towards healthcare as a collective right. Because if you look broader than just one specific pandemic, just this one specific virus, which we're currently talking about and for which we have developed all our policies. If you look beyond that, just to give you one number, one statistic, interestingly, every year globally, the entire so-called entire Belgium, you could say, dies because of lifestyle. So there are 11.5 million people in Belgium, and that is the number of people who die not because of hunger, but purely because of lifestyle, and that is mostly food. Now, if your argument that, or if the hypothesis that that we're evolving to health care and health concern, public health as a collective right, if that would be correct, then I fail to understand why, for example, we are not virtually doing nothing about issues such as lifestyle, which is set to cause up to between 60 and 80%. And that's a number from the CEO of one of the university hospitals here in Belgium, which is an internationally known hospital, the University Hospital of Brussels University. And they give this statistics that over 6% of people are hospitalized purely because of lifestyle reasons. So those are things which presumably they can change. And then that would require measurements, not so much on the individual level, but rather measures that are targeted at the industry of processed foods. And so I failed to, maybe somebody can enlighten me and tell me where all the measures are, but I barely see any measures taken in that regard. So I would I would rather, on the contrary, argue that we are evolving into some sort of individual from an human rights or not human rights, but healthcare as an individual responsibility. Because if you don't mask up, and if you don't keep distance, and if you don't vaccine, and these are not my arguments, but these is how the arguments are being deployed, then you might kill your grandma. So interestingly, and rather than, and although it's being packaged as something collective, all these measures are these infringements upon human rights are being packaged as something collective. What I would argue is rather the opposite, that in actuality we are transferring some part of responsibility towards the individual, and that responsibility is defined in terms not of a holistic approach to healthcare, but rather on a very technocratic perspective in terms of get the jab and mask up and everything will be all right. And we have seen quite the contrary of that. But besides that, so I'm not sure how I would define it, but I hesitate to agree with the idea that there is a transfer towards or a transition towards a collective perception of healthcare in terms of human rights. So, but that's my viewpoint. I'm not sure how. What are your thoughts on this?
Well, thank you for your answer. I agree to a degree. Well, yes, you are right that many things are now the choice of an individual, and I just wanted to draw attention to the fact that earlier we could just say, no, I don't care about my health, so I'm not going to wear a mask, for example, and that's fine. But nowadays, it's not just our obligation because of ourselves, but also because of other people. So that was kind of my point of view. But yes, I understand your point of view as well. There is merit in both. So thank you for the answer and for the wonderful lecture before. I really enjoyed it. So
Thank you.
thank you.
Okay, Nina raised her hand, but after that, I have to remind you that our time for this panel has already passed. So in order not to permit that our food is going to be cool completely, we'll have to conclude our discussion and to arrange another one exactly at 2:30 p.m. of course. Nina, please.
I'll be brief. I'm sorry for taking up lunch break time, but just a few thoughts about the matters that Sofija and Karianne have raised. First of all, you had a slide, Karianne, with the branches of government and the corporate interests, and I think that answers a big part of your question, why nothing is done about lifestyle problems that are harmful to one's health, and that doesn't only include the food we eat, because there are, of course, major companies that are very interested in selling their products as they are. But there's also two more factors to consider. First, the person who, say, eats horribly, mostly endangers just their own health and indirectly perhaps the overall life quality of their family. But you can't compare that to an infectious disease where someone who isn't vaccinated and doesn't wear a mask, etc., can infect many others. Now, naturally, of course, bad lifestyle examples can also influence others, but that's a much more indirect kind of influence. So you could argue that with infectious disease, the risk of an individual's bad behavior is greater to the community as a whole. And the second is the practical feasibility of government measures that can be taken. So if government decides to prescribe compulsory vaccination for a disease, that's relatively easy to implement, and fines can be charged or whatever to those who don't comply. If we have a measure saying that masks have to be worn in public, then there can be responsible people who will report or at least tell those who don't wear masks, hey, put on a mask or you have to exit the building and so on. Naturally, not even that always works in practice, as we all know. But I can't imagine a way for a government to enforce a measure that would force us to eat healthy beyond a very, very major project of eliminating unhealthy food from the marketplace in general, which again would be thwarted by the strength of the corporate interest in the area. So it might simply be a matter of who is endangered and to what extent, and how feasible would it be to introduce the measures in the first place. And as for the shift from individual to collective rights, generally, you can see that in many historical trends, not just when human rights are concerned, a pendulum that swings to one extreme and is then pushed back. What we know now of as individual human rights have been suppressed for centuries before that, and then the pendulum swing to the extreme of complete individualization, of putting the individual before all, which is an unhealthy extreme. It ignores the needs of the society as a whole. It ignores collective needs. And then after a while, it has to go back, but we just have to be careful that it doesn't go back to the other extreme of putting the collective absolutely before the individual, because neither extreme is good. Just some thoughts on the matter. It doesn't mandate a reply, though if there is one, I'll gladly hear it.
Okay, thank you very much. Thank you all for this very fruitful discussion. We are going to make a break right now, and we are returning back for 1 hour at 2:30 p.m. and then we will continue with our next session. Thank you all and see you soon. Bye-bye.
Thank you.
Thank you all very much.
Thank you.